Before we begin, a quick and important disclaimer. The content presented in this video is for educational and entertainment purposes only. The subject of divorce involves complex legal, financial, and personal considerations that vary significantly by state and individual circumstances. This video does not constitute professional legal, financial, or psychological advice. Laws regarding family courts, asset division, and custody are subject to change and are highly localized. You should always consult with qualified professionals, including family law attorneys and financial advisors, to address your specific situation. Viewers are strongly encouraged to conduct their own due diligence and rely on official legal counsel rather than online commentary. Consider the reality that, according to historical trends and sociological data, approximately 40 to 50% of first marriages in the United States end in divorce. Yet, for men navigating this transition, the landscape has shifted so dramatically in the last 30 years that the traditional playbook inherited from our fathers is not just outdated. It is fundamentally hazardous to your future. There is a quiet, profound transformation occurring in American family law and social expectations, a shift that is currently catching a significant portion of the population completely off guard. If you believe that the legal system operates on a neutral playing field or that cultural norms regarding masculinity and breadwinning remain stagnant, you are already behind the curve. In this series, we are going to dissect exactly why the mechanisms of divorce have fundamentally evolved, how the shifting definition of alimony is impacting long-term financial stability, and why the modern man must fundamentally restructure his approach to legacy and household risk before a petition is ever filed. The problem this video solves for you is the critical information gap. Many men enter the prospect of separation with a conceptual framework built on decades-old assumptions about equity, custody, and the societal role of the provider. This disconnect between expectation and the cold reality of current judicial practice often leads to catastrophic financial outcomes and irreversible damage to parental relationships. Today, we are beginning a 10-part masterclass designed to provide you with a comprehensive, analytical view of this evolution. We are not here to offer quick fixes or emotional validation. We are here to analyze the structural changes in the family court system, the economic realities of post-divorce life in the current inflationary climate, and the nuanced cultural shifts that have redefined the bargaining power of parties involved in a dissolution of marriage. To understand where we are, we must look at the historical trajectory of the no-fault divorce movement, which took hold across the United States in the late 1960s and 1970s. This was the catalyst for the modern evolution. Prior to these shifts, divorce typically required proof of wrongdoing, adultery, abandonment, or cruelty. The transition to no-fault regimes effectively removed the necessity of proving misconduct, which fundamentally changed the nature of the marital contract from a permanent legal bond to a dissolvable civil partnership. This shift was intended to reduce conflict and allow individuals to exit unhealthy relationships without the need for litigation regarding fault. However, the secondary consequence of this legal architecture was the creation of a system where the decision to end a marriage became unilateral. One party could initiate the end of the contract regardless of the other party's desire to maintain it. This unilateral shift had cascading effects on how assets are managed, how spousal support is calculated, and how judges view the contribution of each spouse. Over the last 4 decades, the implementation of these laws has evolved from basic procedural changes to complex judicial interpretations that prioritize economic equalization. This means that in many jurisdictions, the court's primary function in a high-asset or even middle-class divorce is not just to divide property, but to ensure that both parties maintain a standard of living that mirrors the marital lifestyle. For the partner who has historically functioned as the primary breadwinner, this often translates to a rigid enforcement of support obligations that ignore the modern reality of dual-income households and shifting career trajectories. We are seeing a trend where historical data regarding household income is weighed against future earning potential in ways that were unthinkable 50 years ago. Courts are increasingly utilizing vocational experts to determine what a spouse should earn, rather than what they are actually earning, which can lead to imputed income calculations that create insurmountable financial burdens for men whose industries may be experiencing volatility or decline. This is not merely a legal annoyance. It is a systemic challenge to your personal fiscal sovereignty. The cultural shift toward equality in the workforce has, in many judicial districts, resulted in a paradox. While women have achieved historic levels of financial independence, the legal standard for spousal support has not necessarily contracted in response. Instead, it has often become more sophisticated, focusing on the duration of the marriage as a primary metric for the duration of the support obligation, often tethering the breadwinner to their former spouse for years or even decades after the relationship has ceased to exist. This masterclass is designed to help you navigate these complexities by moving away from emotional reactivity and toward strategic foresight. We will move through the legislative history of divorce, the financial realities of equitable distribution, the psychological impact of the adversarial process, and the specific ways in which modern technology and communication have changed how evidence is collected and presented in the courtroom. We will examine case studies of how the courts interpret prenuptial agreements, how they handle complex assets like equity compensation and business interests, and how the concept of parental rights has evolved from an assumed maternal preference to a modern, albeit still inconsistent, focus on shared parenting. The goal is to provide a blueprint for understanding the system as it exists today, not as it existed in your parents' or grandparents' generation. You need to understand the language of the court, the expectations of the judiciary, and the economic metrics that will ultimately determine your post-divorce trajectory. By the end of this 10-part series, you will have a comprehensive understanding of the risks associated with the dissolution of marriage and the proactive steps required to manage those risks effectively. This is not about winning or losing in the traditional sense. It is about preservation, clarity, and the ability to maintain your agency in a legal environment that is frequently indifferent to your personal narrative. We will proceed by dissecting the core pillars of the divorce process, beginning with a deep dive into the legal architecture that governs the modern American family, and why your understanding of this framework is the single most important variable in your long-term success. To understand the foundation of your situation in 2026, you must first recognize that the United States legal system for divorce is not a federal monolith. It is a mosaic of state-level statutes that can shift under your feet, based entirely on your zip code. The first critical variable is the distinction between community property states and equitable distribution states. Imagine a scenario involving a couple living in a state like Texas, which is a community property jurisdiction. In this environment, the court begins with the legal presumption that all assets and debts acquired during the marriage are owned equally by both parties. If you, as the primary breadwinner, accumulated significant equity in a business or a retirement account during the term of the marriage, the starting point for the court is often a 50-50 split. This is not a matter of what is fair in a moral sense. It is a matter of statutory property law. Conversely, if you reside in a state that follows equitable distribution, the court is tasked with dividing assets and debts in a way that is just and fair, which does not inherently imply an equal split. While this might sound like a more flexible option, it actually introduces a higher degree of judicial discretion. In an equitable distribution state, a judge can look at a wide range of factors, including the length of the marriage, the earning capacity of each spouse, and even contributions as a homemaker. In 2026, we are observing a trend where judges are increasingly utilizing vocational experts to conduct what is known as an imputed income analysis. Imagine if you are a professional whose industry has seen a downturn. The court may decide that your historical earning capacity or your potential earning capacity, regardless of your current actual income, is the metric that should be used to determine support obligations. This creates a scenario where you could be legally tethered to a support payment that exceeds your actual take-home pay, forcing you into a position of liquidation just to stay compliant with court orders. Let us dig deeper into the concept of alimony or spousal support, because this is where the most significant cultural and legal evolution is occurring. For decades, the system was designed around the model of the single-income household. Today, that model is the exception, not the rule. Yet, the legal machinery for alimony often remains stuck in the past. In many jurisdictions, the duration and amount of alimony are still heavily influenced by the length of the marriage. Case studies from recent filings in 2026 indicate that even in states moving toward reform, the path to ending support obligations is fraught with procedural hurdles. You might assume that if your former spouse begins a new career or enters a new cohabitation, your support obligation ends automatically. This is a common misconception. In most instances, you must file a formal motion to modify the decree, which necessitates legal fees, evidence gathering, and in many cases, a new round of courtroom litigation. The reality of 2026 is that the legal system is increasingly digitizing its evidence collection. Every text message, email, and social media interaction is now fair game for discovery. Imagine if you communicate with your spouse about household expenses or future plans in a way that can be construed as an admission of financial ability or an acknowledgement of guilt regarding the breakdown of the relationship. In the modern courtroom, this information is not just used to establish the timeline of the separation. It is used to build a narrative of your financial stability. Proactive men who are currently navigating this landscape are realizing that the lack of clear, professional communication protocols during the lead-up to a divorce is a primary factor in unfavorable settlements. You are effectively living in a glass house, and the legal system is looking for every opportunity to quantify your assets and your intent. There is also a growing push for the presumption of shared parenting, which is one of the few areas where the evolution of family law is arguably moving toward a more balanced outcome for men. Many states are updating their statutes to begin with the baseline expectation of 50-50 custody. This is a massive shift from the maternal preference models of the past. However, this presumption is often rebuttable. If your spouse can demonstrate that a shared parenting arrangement is not in the best interest of the children, the default position is stripped away. This is why documentation of your active, daily involvement in your children's lives is no longer optional. It is a critical requirement for maintaining your parental rights. You must be able to prove your engagement with schools, medical appointments, and daily routines, not just as a matter of parenting, but as a matter of evidence. As we move through this masterclass, it is essential to internalize that the legal system does not care about your emotional distress or your sense of injustice. It cares about numbers, documentation, and the application of statutes to the facts of your specific case. The disparity between what you think you deserve and what the law allows is where your greatest risk lies. Understanding these mechanisms, the difference between community property and equitable distribution, the way income is imputed, and the stringent requirements for custody, is the only way to begin positioning yourself for a sustainable outcome. In the next segment, we are going to pivot toward a deep dive into the financial forensics of a modern divorce. We will examine exactly how hidden assets are tracked in an era of crypto wallets and offshore accounts, and why your ability to account for every dollar in your portfolio is the only thing that stands between you and a catastrophic settlement. Why are high-net-worth individuals increasingly turning to private forensic accountants before they even consult with an attorney? And what does this tell us about the volatility of the current marital contract? We will break down the specific tools and data points you need to secure your financial future. The transition from understanding legal frameworks to managing financial forensics is where many men find themselves unprepared for the sheer technicality of a divorce proceeding in 2026. You must accept that your financial life during the marriage is not private. It is a shared ledger that the court has the authority to audit completely. Imagine if you have spent the last decade building a portfolio consisting of traditional brokerage accounts, private equity stakes, and decentralized digital assets. In the eyes of the family court, the complexity of these assets is not an excuse for a lack of transparency. It is a signal for a deep-dive forensic investigation. When you are in the middle of a separation, the court does not simply look at your current bank balance. It looks at the flow of capital over the duration of the marriage, attempting to trace every dollar to identify potential dissipation of marital assets. Dissipation is a term you will encounter frequently, and it carries significant weight. It refers to the intentional squandering or hiding of assets that should otherwise be subject to division. If you are a business owner and you decide to ramp up capital expenditures or make unusual distributions right before a filing, the court will likely perceive this as a deliberate attempt to reduce the marital estate. Forensic accountants are now standard players in these proceedings. They utilize advanced data reconciliation software to track transfers, payments, and lifestyle expenditures. In 2026, these professionals are exceptionally skilled at identifying patterns in your credit card statements, tax returns, and even your digital transaction history. They look for anomalies such as unexplained cash withdrawals, payments to third parties that may be disguised as business expenses, or significant increases in investment in assets that are difficult to value. Consider the case of a tech entrepreneur we will call Robert, living in California. Robert operated a successful startup, and believing he could maintain control over his intellectual property, moved a portion of his equity into a complex trust structure shortly before his spouse filed for divorce. He assumed that because the assets were no longer in his personal name, they were off-limits. However, the discovery process, empowered by modern digital forensic tools, allowed his spouse's legal team to map the flow of funds back to his primary income source. The court viewed the transfer as a fraudulent conveyance and ordered the assets to be clawed back into the marital estate for division. This illustrates a critical reality. In the current landscape, the depth of discovery is vast. The presumption of the court is that any asset acquired during the marriage regardless of how it is titled or where it is hidden, is subject to scrutiny. Beyond simple asset tracking, there is the issue of business valuation. If you own or have a significant interest in a private company, the valuation process is rarely straightforward. You will be dealing with business appraisers who use complex models to determine the fair market value of your interest. These models, such as discounted cash flow analysis or market-based multiples, are highly sensitive to assumptions about future growth and risk. If your appraiser assumes a low growth rate, your valuation decreases, potentially lowering your buyout obligation. If your spouse's appraiser assumes a high growth rate, your obligation increases substantially. The conflict is rarely about the math itself, but rather the underlying assumptions that feed the models. You need to be prepared to defend your business performance and your future projections under intense cross-examination. Then there is the issue of debt. Many men assume that if they can prove their spouse was irresponsible with spending, they can somehow insulate themselves from that debt. That is rarely how the law works. In most jurisdictions, debt incurred during the marriage is considered a joint obligation, regardless of which spouse actually signed the loan or who made the purchase. If your spouse accumulated massive credit card debt on hidden purchases, you are likely still legally liable for half of it in an equitable distribution state. This is why immediate financial hygiene upon the realization that a marriage is ending is non-negotiable. You must secure your own financial statements, document all joint debts, and establish a clear line of demarcation for your post-separation income. We must also discuss the role of technology in financial discovery. Today, your digital footprint is an open book. Your spouse's legal team can request access to your cloud storage, your email archives, and your transaction history across multiple platforms. If you have been utilizing cryptocurrency, you might assume it offers a layer of anonymity. In 2026, the technology used by forensic investigators to trace transactions on public blockchains is sophisticated enough to link wallet addresses to your identity, especially if you have ever moved funds through a centralized exchange that requires Know Your Customer verification. The notion that you can effectively obscure assets in the digital realm is increasingly becoming a historical relic. The goal here is not to suggest that you should attempt to manipulate the system. Rather, the goal is to emphasize the importance of precision. You must be able to account for your finances with the same rigor you apply to your professional endeavors. If you lack a clear, documented audit trail of your finances, you are creating an environment where a judge will rely on the estimates and assertions of the other party's experts. This puts you at a massive disadvantage. You need to maintain your own records, engage your own valuation experts, and be prepared to explain your financial history in detail. The volatility of the marital contract today means that the intersection of your personal finances and your legal standing is the primary point of failure for most men. We have moved from a system of simple property division to one of complex financial forensics. In our next segment, we will shift focus from the hard numbers to the psychological and tactical warfare that defines the modern courtroom experience. We will explore how to manage your narrative when the courtroom is designed to strip away your context. Why is it that the most composed and documented men often fare the worst when they fail to understand the emotional framing of their case by opposing counsel? And what are the specific techniques used to paint your history in a light that favors your spouse? We will examine the art of testimony and the strategy of deposition in the high-stakes world of modern divorce. The courtroom in 2026 is less a place of objective inquiry and more a stage for narrative construction. When you enter a deposition, you are not simply answering questions. You are providing the raw material that opposing counsel will use to build a psychological profile of you, the spouse, and the parent. Imagine if you are a successful professional who has spent your career cultivating a reputation for intensity, decisive decision-making, and high-performance standards. In the context of a divorce deposition, these same traits can be weaponized. Counsel may frame your professional success as proof of your emotional unavailability, or your decisiveness as evidence of your rigidity and failure to communicate. The goal of the opposing side is to make your personality traits appear to be the primary cause of the marital breakdown. You must understand that the deposition is the most critical phase of discovery. It is your sworn testimony, recorded for posterity, and it will be used to trap you in inconsistencies. A common tactic in the current legal climate involves the introduction of seemingly innocuous questions about your history, your habits, or your past conflicts. The objective is to establish a pattern of behavior that suggests a lack of empathy or a history of volatility. If you become defensive, frustrated, or overly explanatory, You are giving the opposition the footage they need to present you as an unstable or unreliable witness to a judge. The most composed and effective witnesses are those who treat the deposition as a tactical exercise in brevity and precision. If you are asked a direct question, answer it directly. Do not volunteer additional information, do not try to explain your reasoning, and do not attempt to win the argument in the room. Consider the case of Michael, a corporate executive in New York who found himself in a high-asset divorce. Michael was accustomed to leading meetings and felt comfortable speaking at length about his perspectives. During his deposition, his spouse's attorney asked him about his work travel schedule. Michael, wanting to show how hard he worked for his family, launched into a detailed explanation of his professional sacrifices, his commitment to his firm, and his long hours. That monologue became the centerpiece of his spouse's argument that he was absent, disconnected from his children, and fundamentally prioritized his career over his family. By trying to justify his actions, he provided the narrative that the opposition used to minimize his parental role. In modern litigation, your justifications are your liabilities. The art of testimony lies in the understanding that the judge is not looking for the truth in the abstract. They are looking for the truth as supported by admissible evidence. If your story about a conflict is not supported by contemporaneous notes, emails, or third-party witnesses, it is effectively hearsay. Modern litigation is obsessed with digital receipts. If you claim that you were the primary parent involved in school logistics, but you have no email correspondence with teachers or record of school event attendance, your testimony will be dismissed as self-serving. You must learn to curate your own evidence trail. This does not mean manufacturing a narrative. It means documenting your reality. The men who survive the divorce process with their objectives intact are those who have maintained a clear, organized, and verifiable record of their contributions to the household and the lives of their children. There is a significant psychological component to this. The adversary system is designed to induce stress, fear, and reactive decision-making. You will be bombarded with motions, temporary orders, and accusations that feel fundamentally unfair or factually incorrect. The instinct is to fire back, to issue a retort, to clarify the record immediately. But in the eyes of the court, the person who remains calm and follows procedural requirements is the person who is perceived as the reasonable adult. The person who reacts, who sends angry emails, or who violates temporary orders in a fit of frustration is the person who is perceived as the aggressor. In 2026, judicial officers are increasingly sensitive to the optics of parental conduct. Any evidence of poor communication, even if provoked, is a potential strike against your custody claims. We must also address the strategy of mediation. Often, courts will push for mandatory mediation before allowing a case to go to trial. Many men view mediation as a soft option, a way to reach a compromise that avoids the courtroom. However, mediation is still an adversarial process. Your mediator is not your counselor. They are a facilitator whose primary goal is to get a deal done so that the court docket can be cleared. If you approach mediation without a clearly defined objective and a complete understanding of your legal leverage, you will likely be pressured into a settlement that is far from your ideal outcome. You need to enter these rooms with a firm grasp on what is negotiable and what is not. You should never step into a mediation without a comprehensive understanding of the tax implications of your proposed settlement, the long-term cost of your support obligations, and the specific impact of your asset division on your future liquidity. The disconnect between the human experience of divorce and the mechanical process of the court is the fundamental source of frustration for men in the United States today. You are dealing with a system that has been automated, proceduralized, and stripped of the nuance that characterized your life. When you stop viewing the process as an emotional journey and start viewing it as a high-stakes transaction where your future independence is the primary asset at risk, you begin to change your tactical approach. The goal is to move from a position of reacting to the court's demands to a position of managing the evidence and the narrative in a way that protects your long-term interests. We have explored the courtroom dynamics and the necessity of precise testimony. In our next segment, we are going to pivot toward the most sensitive and often the most contentious aspect entire process, the legal and cultural complexities of child custody. We will examine why the shift toward shared parenting is creating new types of litigation, how relocation statutes can completely alter your parental rights, and why the concept of the best interests of the child is one of the most dangerous and malleable phrases in the entire legal lexicon. What are the specific red flags that you need to be aware of when negotiating a parenting plan? And why do so many men fail to anticipate the long-term impact of seemingly minor clauses in their custody agreements? The concept of the best interests of the child is the most potent weapon in modern family law. While it sounds noble in practice, it is a legal blank check that allows judges to impose their own moral and sociological standards on your family. In 2026, the cultural shift toward shared parenting is undeniable, but it remains a battleground of implementation. Imagine if you are a father who has been the primary breadwinner, spending long hours at the office to secure your family's financial future. During your custody hearing, that professional dedication is easily reframed by opposing counsel as evidence that you are a distant, unengaged parent who lacks the capacity to handle the granular details of daily life, such as doctor appointments, school runs, or emotional support. You must understand that a parenting plan is essentially a contract for the next decade or more of your life. It is not just about who has the children on which weekends. It covers everything from educational choices and medical decisions to extracurricular activities and religious upbringing. A minor clause, such as one stating that major decisions must be made in the best interest of the child, is an invitation for future litigation if you and your ex-spouse do not have a robust, clearly defined dispute resolution process. If you do not have a specific, court-ordered mechanism for resolving disagreements, you will find yourself back in front of a judge every time you disagree on a summer camp or a medical specialist. Consider the case of David, a software engineer in Washington state who signed a standard custody agreement that granted him visitation but left the primary decision-making authority for education with his ex-spouse. David assumed this was a reasonable compromise because they were on good terms at the time. 2 years later, when his ex-spouse decided to move to a different school district that would significantly impact David's ability to participate in his daughter's life, he discovered that he had essentially signed away his ability to contest the decision. The court viewed the initial agreement as a voluntary surrender of influence, and David was left with no legal recourse to prevent the disruption. This case study highlights why you must scrutinize every word in your parenting plan, specifically regarding relocation, decision-making authority, and the definitions of your time with the children. Relocation is another critical pillar, where cultural evolution is clashing with legal reality. In an increasingly mobile society, the desire for one parent to move for career or personal reasons is common. However, relocation laws are often extremely restrictive. If you are the parent who stays in the home state, you have significant leverage to contest a move if you can demonstrate that it interferes with your established parenting time. Conversely, if you are the parent who wants to move, you face a massive evidentiary burden. You must prove that the move serves a legitimate purpose and that it will not diminish the other parent's relationship with the children. In 2026, we are seeing more cases where the court mandates the stay-behind parent to facilitate ongoing contact through digital means, but this never replaces the physical reality of shared time. The role of the guardian ad litem is also something you must be prepared for. This is an attorney appointed by the court to represent the interests of the children. They will conduct interviews with you, your ex-spouse, the children, and even teachers and counselors. They will then provide a report and a recommendation to the judge. Many men make the mistake of viewing the guardian ad litem as a neutral investigator who will see the truth of their parental competence. That is a dangerous assumption. The guardian ad litem is a person with their own biases, their own interpretations of the best interest standard, and their own time constraints. If you fail to present your case to them with the same level of preparation and professionalism that you would use for the judge, you are effectively ceding control of your parental future. You need to focus on what researchers call active parenting documentation. This means maintaining a log of your involvement. Do you know your child's teachers? Do you participate in parent-teacher conferences? Are you present for medical visits? Do you know the names of their friends and the details of their routines? In the courtroom, your word is rarely sufficient. You need the corroboration of third parties and the consistency of your records to prove that you are not just a parent in title, but a parent in practice. The cultural narrative of the secondary father is fading, but the legal requirement to prove your primary importance as a father remains a constant hurdle. The intersection of child custody, financial support, and the division of marital assets is where the complexity truly peaks. Many men lose sight of the fact that child support, while technically designed for the needs of the child, is also a significant financial transfer that is influenced by the custody arrangement. In states where custody is split 50-50, child support might be minimized or even eliminated depending on income disparities. However, if your custody arrangement is skewed even slightly, your financial obligations can increase exponentially. You must understand the specific support guidelines for your jurisdiction, as these are often rigid, formulaic calculations that allow for very little judicial departure. This brings us to the broader question of the long-term sustainability of the modern divorce settlement. When you sign a decree in 2026, you are locking yourself into a future that you cannot accurately predict. Your income may change, the needs of your children will certainly evolve, and the legal environment itself is subject to reform. We are currently observing a trend where post-decree litigation is becoming more common than the initial divorce itself. We will address this in the later stages of our masterclass, but for now, recognize that the goal of your custody agreement should be flexibility without ambiguity. In our next segment, we are going to explore the critical role of your support network and the psychological toll of the adversarial process. We will examine why the most successful men in the divorce process are those who assemble a team of experts, legal, financial, and psychological, before they ever engage in a public conflict. Why is it that the failure to separate your personal identity from your legal status is the most common cause of burnout and catastrophic decision-making? And what are the specific techniques used by elite professionals to maintain their mental clarity while navigating the most high-stakes conflict of their lives? We will break down the structural approach to building your personal defense team. The most significant error men make during the divorce process is attempting to navigate it as a lone actor. This is not just a legal battle. It is an all-encompassing life restructure. The adversarial system is designed to isolate you, wear down your cognitive reserves, and force you into a reactive state where you make decisions based on temporary emotional pain, rather than long-term strategic viability. To survive this, you must construct a specialized support network. Think of this as your personal board of directors. This team should not be composed of friends and family who provide emotional validation, but rather of cold, objective professionals who operate based on data and legal precedent. Your primary asset in this structure is a lead family law attorney who specializes in your specific jurisdictional challenges. Note the word specializes. A general practitioner who handles everything from real estate closings to traffic court is not equipped to deal with the forensic depth of a modern, high-asset, or high-conflict divorce. You need someone who is intimately familiar with the judges in your district, who understands the nuances of the local appellate trends, and who has a track record of handling complex asset division. Interview your prospective counsel as if you are hiring a C-suite executive. Ask for their litigation strategy, their philosophy on settlement versus trial, and how they handle expert witness management. If they do not have a defined process for discovery, they are already putting you at a disadvantage. Parallel to your legal counsel, you need a financial forensic specialist. Even if you believe your finances are transparent, a forensic accountant can identify vulnerabilities you did not know existed. Consider the scenario of a partner who manages the household finances, but is unaware that certain assets, such as unvested stock options or deferred compensation, are increasingly being treated as marital property by recent judicial rulings in states like California or New York. Your forensic accountant will conduct a full audit of your estate, value your business interests, and model the long-term impact of various alimony and support scenarios. This is not about hiding assets. It is about knowing exactly what your baseline is, what your spouse is entitled to, and where the levers for negotiation exist. The third pillar of your team is a specialized therapist or coach who focuses on high-conflict transitions. This is not for venting. This is for training. You need to learn how to compartmentalize your emotional response so that it does not spill over into your court filings or your interactions with the guardian ad litem. The reality of 2026 is that every email you send to your ex-spouse is essentially a draft for a court exhibit. A trained coach will work with you to implement the gray rock method, a communication strategy designed to reduce conflict by providing neutral, brief, and non-reactive responses to provocation. Learning this skill is one of the most effective ways to prevent your spouse's legal team from painting you as a volatile or uncooperative parent. Imagine if you were forced to defend your professional record in a high-stakes litigation without a team. You would be overwhelmed. Yet, men routinely enter the divorce process, which carries a much higher risk to their personal freedom and long-term financial stability, with nothing but their own instincts. This approach is a historical trend toward failure. The men who emerge from this process with their assets and parental rights intact are those who treat it as a managed business operation. They delegate, they verify, and they remain detached from the narrative. They do not get involved in the petty arguments over household items or scheduling snacks, because they know that those arguments are traps designed to escalate the cost of the litigation. What you are looking for is what experts call a defensive posture. This means you do not volunteer information, you do not speculate, and you do not negotiate against yourself. Your professional team will handle the tactical execution of this posture. Your role is to provide the data, maintain the discipline to follow their guidance, and keep your life functioning. This is exceptionally difficult when you are going through a personal crisis. The psychological toll of being accused of things you did not do or having your parenting questioned is immense. This is exactly why the emotional detachment component of your team, your coach or therapist, is just as important as your attorney. If you lose your cool in a deposition, your attorney cannot undo the damage done by your words. Consider the case of Mark, a successful executive who built a robust team of a specialist attorney, a forensic accountant, and a high-performance coach. When his ex-spouse's legal team filed a series of aggressive motions aimed at inflating his imputed income and limiting his visitation, Mark did not react. He did not call his spouse, he did not post on social media, and he did not send emotional emails. He deferred to his team. His attorney drafted a precise, data-driven response that demonstrated the falsehood of the claims, while his coach helped him manage the anxiety of the process. Because Mark was composed, the court viewed his position as reasonable and his spouse's aggressive motions as obstructive. This was the turning point that allowed him to secure a fair settlement without going to a full-scale, multi-year trial. Building this team requires time and financial investment, but the alternative is far more costly. The long-term impact of a poorly negotiated settlement, including support obligations that are miscalculated or custody arrangements that are unworkable, can cost you millions of dollars and decades of missed time with your children. Do not look at the cost of your legal and financial team as an expense. Look at it as an insurance policy for your future. The market rate for top-tier legal talent and forensic experts is high, but the potential outcomes of having them on your side are significantly more favorable than the potential outcomes of entering the system alone. We have now established the structural approach to your legal and financial defense. In our next segment, we are going to explore the most difficult aspect of the modern divorce: the intersection of your professional life and your private conflict. How do you protect your career, your reputation, and your business partnerships when your personal life is under scrutiny by the court? Why is it that the most successful professionals often wait too long to manage the narrative at their workplace? And what are the specific steps you must take to insulate your career from the volatility of your divorce? We will look at the strategies used by high-profile individuals to maintain their professional trajectory, while the rest of their world is in transition. The workplace is the most neglected front in the battle for your post-divorce future. Many men treat their career as a separate sanctuary, assuming that because they are high performers, their personal life will remain compartmentalized. This is a significant miscalculation in 2026. The reality is that a high-conflict divorce is a corporate liability. Your spouse's legal team will not hesitate to subpoena your workplace if they believe it can help their narrative. They look for evidence of your lack of emotional control, your absence, or your financial mismanagement. Your employer is not your friend, and your colleagues are not your confidants. To protect your professional trajectory, you must treat your work life with the same defensive rigor as your legal proceedings. Imagine if you have been the lead on a major project, and your spouse's counsel starts sending subpoenas to your HR department for your communications, your performance reviews, or your travel logs. If you have been discussing your personal grievances with your boss or venting to your coworkers, that information is now discoverable. It can be used to construct a narrative of your instability, your lack of focus, or your professional decline. The most elite professionals understand that the moment a separation begins, their workplace becomes a data mine for opposing counsel. They restrict their communication to professional matters, they avoid all personal venting, and they maintain a disciplined, high-performance output that makes it impossible for their spouse's team to paint them as anything other than a dedicated, stable employee. The decision of whether to disclose your situation to your employer is a tactical choice, not an emotional one. In 2026, the guidance is clear. Keep it narrow, professional, and limited to potential impact on your availability. If you require time for court appearances or mediation, communicate that as a logistical need, not a personal crisis. Frame the request as a temporary adjustment to manage a personal matter that requires your attention, and provide a clear plan for how you will maintain your performance and meet your deadlines. Never use the phrase, "I am going through a divorce and I need grace." Instead say, "I have a personal legal matter that requires me to be away on these specific dates." and I have already rearranged my workload to ensure all deliverables are met. The distinction is subtle but critical. Consider the case of James, an architect who was in the middle of a major project when his divorce filing was initiated. James felt the need to be transparent and went to his senior partner, explaining the emotional turmoil and the impending custody battle. He thought he was being professional, but he had unknowingly created a perception of risk. His partners began to subtly reassign his high-profile clients to other leads because they feared he would be distracted or unavailable during critical phases of the build. James was sidelined not because his performance had slipped, but because he had provided his partners with a reason to doubt his stability. He lost his professional momentum long before the divorce was finalized, simply because he failed to manage his narrative. This brings us to the importance of what is known as the professional firewall. You must proactively manage your reputation to ensure that your professional persona remains untarnished by your personal conflict. This means you do not discuss your divorce in the office. You do not ask for advice from colleagues. You do not use your company email or phone for any divorce-related communications. You keep your work hours dedicated exclusively to work. By doing this, you are not just protecting your reputation. You are creating an environment where your spouse's legal team has no leverage to target your professional standing. If you appear at work every day, focused, prepared, and high-performing, you are building a counter-narrative of reliability that is incredibly difficult for the opposition to dismantle. +1. There is also the risk of harassment or interference. In some high-conflict cases, an ex-spouse may attempt to contact your employer or your professional network to damage your standing. If this happens, your response must be immediate and documented. You should have already had a conversation with your HR department about the potential for personal disputes to cross into the workplace. By being proactive and providing them with a clear, calm explanation of the situation, you ensure that they are prepared to handle such interference if it arises. Your goal is to be seen as the person who is dealing with an unpleasant personal situation with maturity and professional distance, not as the person who is causing drama. Do not overlook the impact of your career field on your vulnerability. Certain professions, such as those in finance, law, or executive leadership, have higher standards for personal conduct. If you operate in these spaces, your reputation is your primary asset. The volatility of your divorce is a direct risk to that asset. You must be prepared to have an honest assessment of how your career might be impacted and develop a mitigation plan. This might include moving sensitive personal data off of your company accounts, being extremely cautious with who you communicate with, and ensuring your performance remains beyond reproach. The goal is to maintain your professional trajectory as an escape from the conflict, not a source of additional strain. The men who thrive are those who use their career as an anchor, a place where they have control, autonomy, and a clear purpose that is separate from the dysfunction of their legal battle. This requires a level of discipline that is difficult to maintain when you are under fire, but it is necessary. You are building the resources and the stability that you will need for your post-divorce life. If you sacrifice your career during the process, you are essentially losing the battle twice. We have addressed the critical need for a professional firewall and the tactical management of your workplace narrative. In our next segment, we will delve into the complex and often overlooked area of post-divorce financial planning. We will explore why the end of your marriage is not the end of your financial exposure, and why you must be prepared for the reality of long-term support obligations and the potential for future modifications to your decree. Why is it that the most robust settlements in 2026 are those that incorporate a multi-decade financial model? And what are the specific steps you must take to insulate your future assets from the lingering potential for court-ordered adjustments? We will break down the structural approach to your long-term financial security. The conclusion of a divorce decree is rarely the end of your financial exposure. In 2026, the modern marital contract often functions as an indefinite economic tether, if not structured with absolute precision. Men frequently fall into the trap of viewing a settlement as a fixed outcome, assuming that once the signatures are dry, their financial obligations are locked in. This is a profound misunderstanding of the legal reality. Statutes in almost every jurisdiction allow for the modification of support obligations based on substantial changes in circumstances. If your income increases significantly, if your ex-spouse experiences a career downturn, or if the needs of your children evolve, the potential for post-decree litigation to revisit your support payments is high. To secure your long-term future, you must build your settlement with a defense-in-depth mentality. Consider the case of Thomas, a professional in Chicago who agreed to a standard alimony arrangement based on his income at the time of the divorce. 3 years later, Thomas received a significant promotion and an equity-based compensation package. His ex-spouse filed a motion for modification, arguing that the change in Thomas's financial status represented a substantial shift in the marital standard of living that warranted an increase in support. Thomas had assumed his alimony was a set amount, but because he had not accounted for the potential of future income growth in his initial settlement, he found himself back in litigation, spending thousands of dollars to defend his financial gains. This is a classic example of why your settlement must be modeled for long-term fiscal changes, not just your current reality. When you are negotiating your settlement, you need to incorporate specific safeguards. One primary tool is the concept of a non-modifiable support provision. Where permitted by state law, if you can negotiate a clause that states the support obligation is fixed and not subject to modification, you eliminate the risk of future litigation based on income fluctuations. However, this is a difficult concession to obtain. If it is not possible, your alternative is to ensure that the definition of income is extremely precise. Do not leave the definition of income to general statutory interpretation. Explicitly define what counts as income for the purpose of calculating your obligations. Does it include bonuses, equity grants, restricted stock units, or capital gains? If you do not define these terms, you are inviting future conflict when those forms of compensation inevitably fluctuate. Another critical area is the structure of your asset division. Many men prioritize keeping the family home, believing it provides stability for the children. However, from a long-term financial perspective, the house is often a liability that requires maintenance, property taxes, and mortgage payments, all of which are paid with after-tax dollars. In 2026, the most successful settlements often involve a clean break where each party takes liquid assets and minimizes long-term joint obligations. If you retain the house, you are essentially paying for a significant, non-performing asset that ties you to your ex-spouse's financial health and local market volatility. Instead, consider the potential of liquidating the marital home and dividing the proceeds, allowing both parties to achieve financial independence. You must also account for the tax consequences of your asset division. A common mistake is failing to consider the difference between pre-tax and post-tax assets. A retirement account of $1 million is not equivalent to a brokerage account of $1 million. The retirement account comes with a significant deferred tax liability that will be realized upon withdrawal. If you are awarded the retirement account and your ex-spouse is awarded the brokerage account, you are effectively accepting a smaller share of the actual value because you are responsible for the taxes on your portion. Your forensic accountant should be running a tax-adjusted valuation of every asset class to ensure that the division is truly equitable. Then there is the issue of life insurance. It is standard for the court to require the breadwinner to maintain a life insurance policy to secure alimony or child support obligations in the event of death. This is reasonable, but you must control the policy. Ensure that the policy is a term policy that decreases in value over time as your support obligations expire. Many men are trapped into high-cost, permanent insurance policies that remain in effect long after their legal obligations have ceased, simply because they did not negotiate the terms of the policy requirement in the initial decree. You want to ensure that your premiums are minimized and that your obligation to maintain the policy ends precisely when your support obligation ends. Finally, look at the integration of your estate plan with your divorce decree. If you pass away, your support obligations may become a claim against your estate. You need to ensure that your will, your trusts, and your beneficiary designations are updated immediately to reflect the terms of your settlement. If you fail to do this, your ex-spouse could potentially make a claim against your estate that exceeds the requirements of the divorce decree. This is a step that is often overlooked in the stress of the process, but it is one that can protect your legacy and your heirs from years of litigation. The goal of your financial strategy is to achieve a separation that is as clean as possible. You are moving from a state of shared economic risk to a state of individual fiscal sovereignty. This does not happen by accident. It happens through the intentional, data-driven negotiation of every single provision in your settlement. You are building a framework for the next phase of your life, one where you have total control over your assets, your risks, and your future obligations. The more time and precision you apply to the structure of your settlement now, the less you will have to deal with the legal system in the future. We have addressed the critical need for long-term financial modeling and the structural defense of your assets. In our next segment, we will delve into the final and most difficult aspect of our masterclass, the psychological recovery and the redefinition of your identity post-divorce. We will explore why the trauma of the adversarial process can lead to long-term behavioral changes if not proactively managed, and why the most successful men are those who view this period as a necessary, albeit painful, transformation. What are the specific psychological markers of a successful transition, and how can you leverage the lessons of the divorce process to build a more resilient and focused future? We will break down the structural approach to your personal and professional evolution in the years following your settlement. The adversarial nature of divorce is designed to deplete your cognitive and emotional reserves. When the dust finally settles and the decree is signed, you are not simply returning to your previous life. You are entering an entirely new structural reality. In 2026, the most effective men view this transition not as a defeat, but as a hard reset. This requires a transition from the defensive mindset of the litigation phase to an aggressive, forward-looking orientation toward identity reconstruction. If you carry the baggage of the legal battle, the resentment, the defensiveness, and the focus on perceived injustice into your post-divorce life, you will be unable to leverage the freedom you have paid so dearly to secure. The psychological cost of holding on to the narrative of the victim is that it keeps you tethered to the very system that sought to constrain you. Imagine if an entrepreneur whose startup failed spent the next 5 years obsessing over why the investors were unfair or why the market shifted against them. They would fail to build their next, more successful venture. The divorce process is similar. You must treat your past marriage and the subsequent legal conflict as a completed project. Acknowledge the data, analyze the failures of the structure, learn the lessons regarding your personal and professional blind spots, and archive the file. To continue relitigating these events in your mind is to consume the emotional energy that you need to invest in your own growth. You must prioritize the reclamation of your cognitive bandwidth. This means strictly limiting the time and emotional energy you spend thinking about your ex-spouse or the legal process, and redirecting that focus toward your own physical health, your professional goals, and your personal development. There is a significant biological and psychological component to this recovery. The stress of the litigation process triggers a chronic state of vigilance, which is detrimental to your long-term focus and performance. Many men find that even after the legal issues are resolved, they continue to experience the hyperreactivity they developed during the court proceedings. You must actively train your nervous system to return to a baseline of calm. This involves prioritizing sleep, consistent physical training, and the elimination of external stressors. This is not about self-care in a superficial sense. It is about physical and mental performance optimization. If your body is still in a state of high-stress activation, you cannot make clear decisions about your investments, your career, or your future relationships. Consider the case of Michael, a former marketing director who, after a 3-year high-conflict divorce, realized that his internal monologue was still filled with defensive rehearsals of arguments he would never have to give. Michael started a structured daily routine that focused on physical conditioning, professional upskilling, and a complete disconnection from his ex-spouse, mediated entirely through professional channels. By treating his recovery as a deliberate, data-driven optimization process, Michael was able to regain his cognitive edge within a year. He successfully pivoted to a new leadership role and established a stable, low-conflict dynamic with his ex-spouse by focusing strictly on the logistics of parenting and nothing more. This success was not a result of emotional closure, but of behavioral discipline. The redefinition of your identity is perhaps the most complex challenge. During the marriage, your identity was likely fused with your role as a provider, a spouse, and a parent. When that structure is dismantled, you are left with a void. Many men fill this void with bitterness or a desperate search for validation. Instead, use this period to reevaluate your values and your long-term objectives. What do you actually want from your life in 2026 and beyond, independent of the external pressures that defined your previous identity? This is the time to pursue the professional risks, the physical goals, and the intellectual interests that you may have postponed for the sake of the marital unit. By focusing on your own evolution, you shift the locus of control from the court and your ex-spouse back to yourself. You must also be realistic about the lingering potential for conflict. Even after the decree is finalized, you will have years of co-parenting ahead of you. The key is to manage this with the same detachment you maintained during the legal battle. Do not expect the emotional dynamics of the marriage to change just because the legal status has shifted. Maintain your professional communication protocols, keep your records, and continue to treat every interaction as a potential document. By maintaining this structure, you protect yourself from the reemergence of the litigation dynamic, and you preserve your ability to focus on your own life. You are building a new, resilient version of yourself that is no longer dependent on the validation or the approval of the people who were part of your past. This evolution is not just about moving forward. It is about building a better infrastructure for your future. The lessons you learned in the crucible of your divorce, the importance of due diligence, the necessity of objective expertise, the power of defensive communication, and the value of financial independence, are now your competitive advantages. You are now more informed, more disciplined, and more strategic than you were when you entered the marriage. The men who survive this process are the men who have become more capable versions of themselves. They have stripped away the illusions of the traditional marital contract and have replaced them with a clear-eyed understanding of the reality of their situation. We have now reached the end of our structural journey through the legal, financial, and psychological landscapes of the modern divorce. In our final segment, we will synthesize everything we have discussed into a comprehensive roadmap for your future. We will discuss how to maintain your focus over the long term, how to prepare for the inevitable changes in your life and the law, and why the most resilient men are those who view their future not as a series of reactions to their past, but as a deliberate construction of their own making. Why is it that the final stage of your evolution requires a complete detachment from the emotional baggage of your previous life? And what are the specific steps you must take to ensure your long-term autonomy remains protected? We will close the masterclass by focusing on the ultimate goal: your total personal and financial sovereignty. Total personal and financial sovereignty is not an endpoint you reach by accident. It is the inevitable result of a decade-long commitment to rigorous self-management, strategic detachment, and the meticulous construction of your own reality. By this point in the masterclass, you have seen the entire architecture of the modern divorce process, from the legal mechanics of equitable distribution to the psychological warfare of the deposition room. You understand that the system in 2026 is not designed to support your personal narrative. It is designed to quantify, divide, and dispose of marital assets with clinical efficiency. The most resilient men, those who emerge from this transition not just intact but thriving, are those who have fundamentally redefined their relationship with the institutions that govern their lives. The final stage of your evolution requires you to internalize a philosophy of radical ownership. This means you stop looking for the system to provide justice or fairness and start providing it for yourself through the systems you build. Your sovereignty is protected by your ability to forecast, your willingness to document, and your capacity to remain indifferent to the pressures that used to define your behavior. Consider the historical trends that favor those who operate with a long-term horizon. Men who have successfully navigated this landscape have shifted their perspective from a focus on the immediate stress of the divorce to the long-term compounding effect of their post-divorce choices. They recognize that their financial future, their parental legacy, and their professional standing are not subject to the decisions of a judge. They are subject to the daily execution of their own strategy. Imagine if you had approached your life as a series of managed risk portfolios. In this model, your career is a growth asset, your health is a foundational asset, and your relationships are maintenance assets. When you remove the volatility of an unstable marital contract, you are essentially cleaning your portfolio. You are no longer responsible for the financial leaks created by joint liabilities, the emotional drag of a high-conflict partner, or the legal risk of an undefined personal contract. This is not about cynicism. It is about the optimization of your resources. By reclaiming your time, your capital, and your attention, you are providing yourself with the raw material to build something vastly more stable than what you had before. The data shows that men who engage in active, long-term wealth management following a divorce, those who prioritize liquidity, tax efficiency, and the protection of their equity, experience significantly higher levels of long-term economic stability. But this is not just about numbers. It is about the ability to say no. When you have achieved financial sovereignty, you are no longer forced to accept compromises that you do not believe in. You are not forced to stay in an unfulfilling job. You are not forced to accept an inequitable settlement. And you are not forced to remain in a dynamic that threatens your mental or physical health. The freedom to walk away from any situation that does not align with your objectives is the ultimate metric of your success. However, the threat to your sovereignty never truly disappears. The legal environment in 2026 remains fluid. New statutes, evolving judicial interpretations of alimony, and changing definitions of parental rights will continue to emerge. This is why you must remain a student of your own risk profile. You should never be so confident that you stop monitoring the legal and financial environment. Continue to engage with experts, continue to update your estate plan, and continue to refine your understanding of the jurisdictional risks that govern your life. The men who fail are those who believe that because they survived the initial divorce, the threat of legal intrusion is behind them. The men who win are those who operate as if the next legal challenge is always a possibility, preparing for it with the same precision that you have practiced throughout this masterclass. Furthermore, look at the impact you have on your children. By demonstrating what a disciplined, calm, and sovereign man looks like, you are teaching them more than any lecture ever could. You are showing them that they do not have to be victims of their circumstances, that they can navigate complex conflict without losing their identity, and that their long-term well-being is something they must proactively construct. Your ability to provide them with a stable, secure, and focused environment is your greatest contribution to their future. This is the ultimate long-term ROI of the discipline you have practiced. You are not just building your own life. You are establishing a standard of excellence that will influence your family for generations. The transformation you have undergone is not limited to your bank account or your legal status. It is a fundamental shift in your character. You are now someone who has been tested by the most aggressive pressures of the modern world, and who has maintained his composure and his integrity. You have learned how to deconstruct a lie, how to build a defense, and how to define your own value outside of the approval of an institution. This is the definition of sovereignty. It is the ability to stand in the center of a chaotic and indifferent system and remain entirely unshaken. As we conclude this masterclass, remember that the goal was never just to provide you with tactical advice. The goal was to initiate a fundamental change in how you perceive your role in your own life. You are the architect, the strategist, and the owner of your future. The system will continue to evolve, the laws will continue to shift, and the world will continue to present new and complex challenges. But you now possess the structural understanding and the tactical discipline to manage those challenges without sacrificing your autonomy. You are the only person responsible for your outcome. Treat that responsibility with the seriousness it deserves. Build your systems with the precision of a professional, and continue to invest in your own long-term growth. This is the only path to true and lasting sovereignty in the modern age.